same principle. It's something that I think we'd all grasp very readily. And I said to Cardinal Pell and Archbishop Jensen, I have no disagreement with that. I've thought about this issue, and I think this is a case of justified discrimination. But if there is a charter or a Bill of Rights, it won't be a Premier receiving representations from the churches on this who will make the final decision. My decision was not to support the Green amendment to the Anti-Discrimination Act. It will be judges who will make a decision about whether that behaviour, that is the exclusion of churches from the Anti-Discrimination Act, is compatible with the human rights document. The decision will migrate from the political arena, where you can have an influence on it, to the courts, where you can have no influence. And that's the important point. Under the model that's been put forward by Father Brennan, you've got a massive increase. The real theme of his report is the huge increase in the power of the Human Rights Commission. Indeed, if I understand it correctly, the Human Rights Commission will end up hearing cases about alleged abuse of rights the way at the present time anti-discrimination boards in the states will hear cases about alleged discrimination, or the way the Human Rights Commission hears cases now about anti-discrimination at the federal level. So it makes itself the arbitrator, and the rights it can have reference to are rights not in Australian law, but in international charters. And all of a sudden a body that was an advisory body, an educative body, becomes a body swollen with significance, and you don't elect it, the Human Rights Commission. It just showed, in my view, its lack of judgment by launching an inquiry into whether Australia needs religious vilification laws. I've dealt with this before, and I've argued that it would be an exercise in absurdity for us to start saying that certain religious behaviour or religious arguments are outside the law, and other religious behaviour or religious arguments are permitted by the law. I quoted Thomas Jefferson, who said, "Whether my neighbour believes in one God or 20 gods, it doesn't matter. It neither picks my pocket nor breaks my leg. Truth is great and will prevail if left to itself." It's not an area where the state ought to be making itself busy, intervening and trying to sort out religious disputes like that appalling case in Victoria, which resulted from their religious vilification laws, that resulted in millions of dollars being spent on prosecuting two evangelical pastors, because the Victorian Human Rights Commission sent representatives, agitated people, to go and hear them speak and then lodge a complaint. It was all artificial. It was designed to get some prosecutions going under the Religious Vilification Act. But it so discredited the cause, and I think we've now got a very strong case in arguing against any recommendation out of this federal inquiry into whether Australia should have religious anti-vilification laws. I conclude by saying, as I set out at the start, this is a big change in how Australia governs itself. I'm talking about the Charter. It represents a shift in power to judges. Under the New Zealand model or the Canadian model or the British model, the parliaments, which in theory have been able to overrule decisions of the courts, have never done it, because politicians are reluctant to take on courts where the courts have said, here is a human rights abuse. And it'd be even harder to have our parliament overrule a court given the position of the Senate in the Australian system. The opposition parties normally have a majority in the Senate. The judges will have an accretion of power, and they're non-elected. You can go to governments, you can't send delegations to judges to put your point of view. This is very, very significant for the churches. If you've seen your federal member of parliament on no other matter, you really should go and see him or her on this. There's a window of opportunity. The federal government will make a decision. It may be sooner rather than later. There is a real prospect, as strong a prospect as the alternative, that they could be attracted to a backdoor version of a Charter of Rights. You can have a big impact if you take a significant delegation in there to argue to the MP that it's not something Australia needs or the Australian electorate has asked for or the Australian electorate would endorse at a referendum. If it enters by the back door, you could be regretting it for a very long time. Thank you.